So welcome everyone to our second seminar for the Institute for Cybersecurity. We're really excited about this series actually because we've almost got a full booking for the entire year, which is great. And we had Nigel Fair talking last week, and this week we have the wonderful Lyria Bennett-Moses. I'm just so excited that Professor Lyria Bennett-Moses is going to be talking for us today. And I think it shows the spirit of the multidisciplinary institute that we are. And I know Lyria doesn't want a long introduction because she's got so many exciting and wonderful things to talk about. But what I will say is that she's an important member of our institute. She's a faculty lead for law, and she does many, many other things. In fact, I do suspect there's more than one of you out there, Lyria. There must be some clones. But she's going to give you a wonderful presentation about, and I'm sure it will challenge us as well, about looking at the law in terms of the context of cybersecurity. And I'm going to pass it straight over to you, Lyria, if that's okay.
Thank you very much, Monica, for your very, very kind introduction. So I'm going to share my screen and let's hope this works. Okay, can someone confirm that they can see the slides?
Yeah.
Wonderful, thank you so much. So first of all, thank you, Monica, and thank you, IFCYBER, for letting me speak to you all this morning. You know, I think it's always good to start a presentation with the one message you really want people to remember. So here it is. I want everyone to remember why interdisciplinary research and thinking about cyber is essential. So if nothing else, that's my core message. But I want to start off with the way that law often gets talked about in really confusing ways in the context of cyber. So this is my slide called The Wrong Questions. And the first time I encountered the wrong questions was actually when I was in Germany and was listening to a presentation by the Bundesverband der Deutschen Industrie, or BDI, which used a map that they'd created with Deloitte. And this map purported to be all the countries that have laws that deal with cybersecurity. But as best as I can tell, what they actually did in constructing this map was some kind of internet search for Cybersecurity Act. And if the country concerned had legislation that was called something like Cybersecurity Act, and there might have been a few variations allowed for that, then it was in and they had law that dealt with cybersecurity. And if not, then they didn't. So Australia was black. We had no cybersecurity laws. So the argument was, according to this map, is we're sort of behind the 8 ball. We haven't yet done anything about cyber and so forth. And that was very much the rhetoric of the presentation. Now, that seems to me a really silly way to do it. We had critical infrastructure laws. Germany had critical infrastructure laws. The only difference is that our laws talked about security of critical infrastructure, whereas their law talked about cybersecurity of critical infrastructure. So realistically, why that makes their law is better than ours was a bit of a mystery to me. But that's sort of one wrong way to look at the problem. The second wrong way to look at the problem is what I call an overly technology-specific focus. So, you know, does the legislation specifically refer to cyber? Or if we're looking at litigation, does the case specifically involve a cyber attack? And unless that's the case, you know, it's got nothing to do with cybersecurity. And there's a little bit of this kind of thinking, I think, that's gone into the new cybersecurity bill, in the sense that we are now suddenly in Australia feeling a need to mention cyber. And that's fine. There's not necessarily a problem in mentioning cyber, but it's interesting that sort of tendency to do so, or that pressure to do so, to look like the government is responding to this important area of concern, that you sort of have to mention the word somewhere. Whereas I'm going to argue, arguably, you don't. But the third wrong approach, and the other one I don't want people to think I'm taking, is the kind of nothing to see here approach. You know, lawyers and regulatory theorists will remember the sort of Lessig-Easterbrook debate, but this is the idea that this is all just about the law of the horse. You know, we don't have to, you know, we don't study the law of the horse, we study contract law, tort law, and so forth. Therefore, we don't need to worry about what the law says specifically about cyber. We can just sort of ignore the context altogether. And that's also not the right approach. So before I go on to talk about what I think the right approach to all of this is, a little bit of terminology, because I'm aware that not everybody here is a lawyer or a regulatory theorist for that matter. So here's what I mean by these words. law generally comes with an ought due to authority, right? It's the state, for example, saying don't murder people. And there are different sources of law. International law, which is what nation states have to comply with, constitutional law, legislation, which includes all the things that come underneath that, as well as in Australia, case law, because we're a common law country. So that's the judge's decisions that influence how the law is interpreted over time. So all of that is what I mean by the word law. Regulation is another word that gets thrown around. It usually gets thrown around in really confusing ways. But the easiest way I like to think of it is it's ultimately about power and influence. And the best definition I've come across is that by Julia Black. So the sustained and focused attempt to alter the behaviour of others according to defined standards or purposes with the intention of producing a broadly defined outcome. So basically you're trying to get to a particular destination through influencing other people's behaviour. Now, there's various qualifications on this broad definition. One is that Julia Black says it's about intentional acts. So one could say the weather influences people's behaviour, right? People are more likely to take an umbrella with them if it's raining, but that's not regulation, right? Because it's not an intentional act unless you believe in God, in which case maybe it is, but for current purposes, it's not an intentional act. Whereas it can be an intentional act, for example, by a standards body. We are going to encourage people to follow standard XXXYY, and that is going to produce a broadly defined outcome, whether that's related to cybersecurity or better information management practices or whatever it might be. That is regulatory. It is a deliberate act. Now, regulation can take a variety of forms, sticks and carrots. Sermons, so just telling people what you think they should do. Architectural barriers, so where you're actually building into systems sort of restrictions that kind of force behaviour to follow a particular direction. A really easy example of that in the physical world is speed humps, but we've all encountered similar things while we're navigating the internet. And default, so this is sort of what gets sometimes called nudge, the idea that you set a particular set of defaults and most people will stick with that default. So you influence their behaviour by choosing what the default will be. And you can use all of those mechanisms, if you like, to make whatever you're trying to get people to do, the desired behaviour, because remember this is an intentional act, the most rational option or the most likely outcome. Now, there are different types of regulation. We can talk about, purely top-down regulation. We can talk about self-regulation, which is really an organisation deciding it's going to do particular things internally to that organisation to influence the behaviour within that organisation, because organisations are complex things. There's often a number of steps that the leadership will have to take to get the regulation moving in a particular direction. Now, the important point to note about regulation is that it includes, but is not limited to law. Now, a few things I want to say about this distinction. One is the change in terminology within government, which I think has been really interesting. It's very rare now to see a document come out of government that even uses the word law. They tend to use the word regulation. Now, law is an example of regulation, so it can capture law, but there are times when what you want is actually law, and sometimes it's helpful to use that word so that everyone knows what you're talking about. In other words, if what you're proposing to do is ought statements with consequences, like everyone must do this, and if you don't, here's the penalty or here's the consequence, then we should use the language of law to recognise that and not hide behind the language of regulation. But the other thing that I think is a little bit more concerning is that when we start using the word regulation, we tend to use it with an object. So we talk about regulating something, right? Now that might be regulating artificial intelligence, that might be regulating the Internet of Things, and so forth. And once we start doing that, we really get into problems because it narrows the way you think about the problem, right? If, for example, you say, how do we regulate IoT, right? How do we do that? Then what you'll come up with is inevitably going to be framed by the Internet of Things. It's going to be, if you like, technology specific. You're no longer going to be looking at it with the same broad lens as if you ask a much broader question. So that comes back to why I've deliberately expressed this as about regulation for cybersecurity, regulation that will therefore get to an end state, greater cybersecurity, rather than regulating some particular kind of technology. The other important risk about using the word regulation is that we forget what's already there. Going back to that earlier point, it's very easy for people to say, oh, Australia doesn't regulate to do with cybersecurity because it doesn't mention the word cyber. It's a tendency to go back to that and not recognise that we do through, for lack of a better word, ordinary laws. And I'll come back to an example of what I mean by that in a minute. But it also means that we ignore the fact that sometimes the best solution is to reform broad laws rather than to create new laws designed for a particular technological context. So in other words, sometimes maybe we want to reform consumer law with that broad lens and fix things that aren't working well, including in new contexts like the Internet of Things, rather than ask, how do we specifically do something about the Internet of Things? It's a subtle distinction, but I think it's an important one. And the final point about the move to use the word regulation is this, and this is a point made by Roger Brownsword. Law addresses citizens. When you pass a law that says, you know, you ought not to do this or don't do this, you're speaking to people as citizens. You're saying, citizens, this is what your parliament, after a due process, has decided, you know, people ought not to do, and here's going to be our collective decision about what the consequence of doing those things should be. And you're addressing people, for lack of another word, as moral agents. You're speaking to them. When you regulate in that broad frame of just trying to get to a particular outcome, sometimes that can be ignored. And sometimes we do things when we regulate and we're using that idea of all we care is about the end state. We're no longer addressing people as moral citizens, as part of a moral community who we can talk to, and instead just forcing them down particular channels. And the point Roger Brownsword makes is that's fine occasionally. He's not arguing against speed humps. But if we do that at scale, and if we start only talking that language, we're changing our society in pretty fundamental ways. So what's my question? My question is this: how does, and for now I'm going to look at the law, but I note that we could look at technical standards or other categories there as well, contribute to a sustained and focused attempt by government, in this particular case, again, we could look at other bodies if we wanted, to alter the behaviour of others according to defined standards or purposes with the intention of producing better cybersecurity. And by that word, I'm including things like resilience and other words that get thrown around, but with the end state that we want in this particular area. And not only how does the law currently contribute, but can we do better? Okay, so I promised I'd come back to this point about it's not only cyber laws. What I've copied here, and I think I could have taken almost any organisation's terms and conditions and found something similar, is, this is from Dropbox, is terms of service. So when we contract in law, normally at a general very high level, companies and organisations and individuals promise things to each other, right? And there can be implied promises where the courts will read things in. And so often organisations try to make sure that certain implied promises aren't there. And that's an example of what you can see in this term from Dropbox's standard terms and conditions. It's saying we are only delivering the services as is. We're not even promising it's fit for purpose. We're not promising it doesn't infringe the law. We're not promising anything about it at all, even if that might otherwise be implied. And we're so definite about this, we're putting it in all caps because people love reading all caps. And you know, we're not promising anything. Now, what does this do? Well, when organisations start doing things like this at scale, they don't have the same incentives to protect people's data. So the data in this case being stored on Dropbox, because if they don't, and if there's a data breach and so forth, they can then rely on these kinds of clauses to say, we're not liable, right? And so they don't face the consequences of the breach, the individuals do. But of course, those individuals have very little power to do anything about it because most of them are just ordinary consumers without negotiating power. So what the law does, and this is consumer law now, is it creates protection. So if you look at the final words there, not in all caps, you know, some places don't allow the disclaimers in this paragraph, so they may not apply to you. What's that all about? That's about consumer protections. And many countries, including Australia, will have consumer law that does protect people, right? So it will say things like, actually, you can't disclaim in warranty that the goods you're supplying or the services you're supplying are fit for a particular purpose. We're not going to let you disclaim that. We're going to force you to take that on and do something about it. So this is an example of a very general set of legal protections. Consumer law doesn't only apply to the Internet of Things or only apply to internet services and so forth. It applies to everything, but it impacts on the ability of companies like Dropbox to disclaim warranties and therefore offload the risk, if you like, onto the consumer, which then means, if you think about it, that they have greater incentives in those jurisdictions not to be liable to the consumers for providing a product that's, you know, dodgy in particular ways, right? So we can think of this as an example, this general consumer law, as an example of something that does actually regulate for better cybersecurity, because it returns, if you like, incentives to companies to at least meet that kind of minimum standard, at least for products that are provided to consumers. Now, this can make everything look huge and unwieldy. If I'm talking about contract law and consumer law as being relevant to cybersecurity, does that mean we can only have discussions if you know all the laws, right? And obviously not. And what we did, because of this concern, largely actually following the presentation in Germany, with the University of Melbourne, with financial support from the Cybersecurity CRC and moral support from many other organisations, is that we created a cyber law map. And anyone can access this. The link's on the slide. It's part of Ostly Communities, which is a free legal information service. And what we've tried to do is to map out the areas of law that we think, if you like, can in some circumstances regulate for cybersecurity, or for that matter, maybe potentially reduce cybersecurity. So laws that have an impact on cybersecurity, cyber resilience, and so forth. And here's our heading so far. I'm not going to go through all of these because that would be a very long and incredibly boring presentation. But these are the kinds of areas of law that we found that we believe actually have, should be looked at by someone trying to understand the law's influence, regulatory influence over the state of cybersecurity in Australia. It's only Australian, we haven't done international law, but there's a whole variety of things here. And you can see that consumer rights is right down the bottom there as one of the areas of law that will have an influence over cybersecurity. It's not perfect. We are not advertising this as complete. It's very much, if you like, a bit like Wikipedia. It's a community project. And I would really encourage anyone here who thinks we've made a mistake or left something out that's really important, or we haven't updated something yet, to reach out. There's an email link on the page. Let us know, and we'll keep making this map better. Because I think this is a really good resource for anyone who's interested in the sort of legal landscape, if you like, that sits around cybersecurity. So please do join us. Now, another kind of map, and this is one we haven't done, is to try to list all the regulators. See, here's my attempt. This is only a slide, but I'm very grateful for anyone who thinks I've missed someone, of the various government entities with some kind of regulatory influence over the state of cybersecurity, or who've stepped into that space and are doing something. Some of these are more about cybersecurity in government, others are more about cybersecurity in the community, but nevertheless, this is my map. You'll see a long list under telecommunications, because telecommunications regulation is complicated. It's obviously very important for cybersecurity, but there are also lots and lots of entities involved. So this is a sort of bit of a map there. And going back to my earlier point that, of course, it isn't just government. There are lots of other regulators. Just for completeness, here's some other entities, and again, not complete, that have regulatory influence over cybersecurity as well. All right. So I don't want to spend a lot of time, though, looking at the way things are, because it's kind of boring and it would take me too long anyway. I want to go into, okay, how can we make this better, right? And I'm putting this in the form of crazy ideas. So here's just a few. You can reject them or not, but this is the kind of thinking we need to have to work out how can law really help here. So I'm not saying my ideas are great ideas. I'm just saying, let's start thinking like this. And the best way to ideate is to start with something that's perhaps a little bit crazy. So here's crazy idea number one. And I should say some parts of this idea came out of a conversation I had with Rachel Falk, not the whole thing. So I take full responsibility for it, including all its craziness. But I should just acknowledge that. Rachel Falk, CEO of the Cybersecurity Cooperative Research Centre. All right. So here's the crazy idea. Right? Let's suppose we said that every time there's a data breach, right, the data custodian, the person who is holding that data, who, if you like, is the person in the best position to have had prevented that breach, has to pay every data subject, every person whose data is compromised, some amount of money. Now, I've put on this picture $100. We could get an economist to see what the right amount is for my scenario, or we could even have different amounts depending on the sensitivity of the data or some other criteria. But the basic idea here is some kind of strict liability. I don't care what the data custodian did wrong. They're in the best position to improve their practices in terms of cybersecurity. If the data is compromised and all of these people of whatever it is, their credit card numbers, their dates of birth, whatever's been lost, they are not in a position to protect themselves. So we are going to force, under the law, in my hypothetical, a money transfer from the data custodian, $100, say, to each individual whose data is compromised. Now, what happens then? If that's the law, what will people do in response? So this is that sort of regulatory type question, right? The first thing data custodians will do, I think, is really think about the data they're holding, right? If every person's data you're holding is a risk, then you're not going to hold data that you don't really have a use for. So the first thing I think they're going to do is work out, how do we minimize our data holdings to what we actually need and can use? Now, organizations currently have no incentive to ask that question at the moment, but this will force it on them, and they will inevitably start having good data deletion programs, right? Which is the first good thing we're getting out of this. The second thing they'll probably do is go, oh my gosh, we're holding the data on, I don't know, 20 million people. This is going to be a really big risk for us if it goes bad. We're going to need insurance. So they'll go to the insurers and they'll say, we want insurance for this risk, right? We want you to pay out instead of us paying out if it turns out we have to make this payment. Okay, and what will the insurers do? Well, my guess is they'll build price signals into their product. So they'll say things like, if you can certify that you conform to this particular standard, whether that's a cyber standard or an information standard, an information management standard, or some other standard, the Essential 8, I don't know what they'll pick, but the insurers will pick something and they'll say, if you can confirm and have certified or audited that you conform to this standard, we'll give you a cheaper product, or we'll only insure you if you do it, or something similar. So they'll create products with price signals that will then mean that all the data custodians will start engaging in better cybersecurity practices and information management practices more broadly. So we probably won't even get as many payouts because the practices will get better. But if there is a data breach, what happens? Individuals get some kind of compensation, both for that sort of annoyance factor that they're all now having to, change their credit cards or take out their own insurance against the risk of identity fraud or something else. So they get some kind of compensation for that, as well as some sort of money as against the risk of something really bad happening to them, say identity fraud or something similar. And so at least there's some partial compensation for that, although you'd preserve their rights to litigate if, they had a $1 million loss or something, really significant out of all of this. So the idea is, and I'm calling it a crazy idea on purpose, I have no idea if it would work. I have not talked to anyone else about all the complications that might arise, but it shows how law can potentially be used by creating a strict liability regime in ways where the consequence, as I map it out, would be better cybersecurity practices across the board, and in particular, a better result for consumers, who are the people least able to protect themselves in this particular scenario. All right, so that's crazy idea number one. Crazy idea number two is also not terribly new. I know Data 61 has done some work on labeling for Internet of Things products. But here's my slightly, I've taken it a bit further than Data 61. So this is crazy idea number two. Now you've got a problem with the Internet of Things because you can maybe do a security assessment and have some kind of rating that consumers can understand. But realistically, that's an oversimplification because the risks are quite diverse. And also the cyber risks will change over time. So you sell a device with a very fixed settings. It's very hard to sort of change certain things in that device depending on how the device is set up over time. So we'd expect the cybersecurity, if you like, rating to decrease over time, right? So if you have a sort of label which has a sort of, thing like your fridges do, the Energy Stars, that rating will eventually become obsolete, and something that looks like a lot of stars will have less stars over time. So how do we deal with this? Again, crazy idea number two, you require this system. So you make organizations as part of consumer law do it. Instead of putting a rating on the item that you're selling, you put a QR code on the thing you're selling, right? That lets people go to a site that can actually be kept up to date for that particular product in terms of its current cybersecurity rating. And not only do you put some kind of signal, whether that's stars or something else, the sort of very simplistic version, but you can actually demand risk disclosures. The law does this already in the context of providing information about financial products, right? So when you're putting some shares on the market or whatever it is, you have to disclose certain things about the risks inherent in that investment, and you have to have a whole long complex document which discloses all of those risks, right? I'm not suggesting a long and complex document, but you could have a requirement for risk descriptions, right? Where people selling these products have to disclose all of the potential risks. So as well as the sort of general star rating, you can have some more specific risks associated with particular products that you can very simply explain to consumers who are interested enough to scan the QR code and find out more about the cyber risks of their new product. And finally, you can have an option, again, on the same page that they get to when they scan the QR code, that lets them sign up to alerts. So if there is a security breach in future that compromises this product and there is some kind of mechanism for patching it, it's much easier for the company to reach out to people, with an email or something and contact them and say, there's this new risk, either unplug the light bulb, it's too dangerous to have it in your house, it's going to compromise your whole network, or you can keep using the light bulb, just do this update if there's a mechanism for doing that.
Now we've got just under 5 minutes to go.
Oh,
can I ask people to start putting their questions in the Q&A section too?
Excellent. Thanks, Monica. So I'll finish this one up really quickly and just say, there's a lot of questions here that I'm not answering. How do you do the stars? I mean, we could use the 13 practices in the Australian code of practice and have a star for each and get up to 13 or something. We could do something different. The government could mandate particular kinds of disclosures. Think about what works really well here. We could talk to consumers about what are the issues they're most interested in, or what are the things that are going to cause the biggest risks. The entire thing, of course, doesn't just need the law to impose some kind of requirement. It would also need consumer education of some kind so that people are at least aware of what the stars mean, how to use the risk descriptions and so forth. So anyway, crazy idea number 2. Other crazy ideas, and I can come up with a whole range of these. I'll just go through some really quickly. A requirement for machine consumable privacy policies to facilitate automated privacy preserving search. So we can go on Google now and we can do an image search which says, only show me images I can put in my slides for free. And I can do that as a search, and all of that information is already keyed into the images that Google is using to put in its search. It's captured in the metadata. So we could have privacy policy metadata to facilitate better searching. So people who are looking at products that will protect their information can then do searches on the internet and only find things that meet their criteria. Another one, we can leverage government procurement to require contractors to government to comply with certain cyber and information standards, including the code of practice or anywhere else we want to get them from. And if government procurement does that, that will help set industry norms, because a lot of companies want to be able to provide their products to governments, which is a big consumer. We could have critical infrastructure protection that, and here's a little bit of a pointed point about the current bill, that focuses on what's actually critical, that doesn't pretend that everything that happens at UNSW is critical, because it isn't. So we narrow it down to something that we actually can protect. We be honest with ourselves about that. And then we don't assume that government's always going to be the best entity to fix things when they go wrong, right? It's not about government's here to help you and here's the instructions you now have to follow. It's a little bit more open-minded about where the really good protection is going to come from. So we can do all sorts of things, but we do all of these things, or we think about these ideas in the context of what can law do that will ultimately produce the kinds of outcomes we want. So I'm going to finish up moving into the questions. I have 2 questions for you as well, which you can put into the Q&A, or we can have a conversation later. What's your crazy idea? I honestly believe that the best way to get started with this area is just to think, to ideate, to put everything on the table. Not all of them will work. And that's sort of the second part of my point. And this is one specifically for Monica, which is how can we work together to evaluate the better ones? So anyone, including me, can come up with a crazy idea. They're not all going to work. But the only way we're going to work out what's going to work is working with, people who have the technical knowledge, people who understand the psychology, people who understand what law can and cannot achieve, people who understand regulation, people who understand the business context and what organisations might do in response to particular laws and so forth. In other words, we need to work together. And that is what I am very much looking forward to inside of IFCYBER, because I do believe that is at the core of its mission. So Monica, back to you.
Oh, Lyria, thank you so much for such a wonderful talk. And there are a squillion questions coming in, so I will try to endeavour to ask as many as I can in our last 15 minutes. But gosh, yeah, just to say, you've got my mind working. So thank you for that. The first question we have is from Megan Smith, and she states, perhaps add Communications Alliance to other telecommunications regulators. What do you think of that, Lyria?
Yeah, I promised my list wasn't complete, and I thank you for, I will add that to the next time I do this presentation. That's a really good one. Thank you for that.
Great. The next is a question to actually, could you please just recap which law did you say you'd use for crazy idea number 1 to make data custodians pay out to people if their data's breached?
So I would actually do that through, I mean, it could be done through the Privacy Act, would be one legal mechanism. So at the moment under the Privacy Act, there are data breach notification laws where you have to tell people that there's been a breach, but there's no other consequence. And one of the things the Privacy Act does really badly in Australia is consequence, right? There's notifications, there's lots of like, these are the principles you should, conform to, lots of that. But when it comes up to actually penalties, I think we can see from the very different responses, like Europe under the GDPR, when it thinks companies don't comply with something, versus the Australian regulator, which is OAIC, I think we can sort of see the difference in terms of how those two regimes work. We also don't get a lot for end consumers, right? The process for end consumers is quite convoluted in the Privacy Act. You've got to go, first of all, to the OAIC, for the organisation to make a complaint, then OAIC and make a complaint, and then OAIC decides whether it can go further and so forth. It's quite cumbersome on consumers to get to. Maybe if one consumer has the patience to go through it all, they'd get their $100 or something, but it's really not worth anyone's time. So we don't really have in our Privacy Act the same sort of incentive for compliance and good practice that we can see coming out of Europe. So what would work, I think, there's different ways to make it work. You can have much bigger penalties. The problem with that in Australia is OAIC is under-resourced. So even if we did put in a big penalty, they could maybe start one piece of litigation a year or every second year or something. They just don't have the resources in Australia to be the main serious regulator. In fact, we're seeing ACCC sort of step in and do some of that, but they can't do everything. So ACCC can come in if organisations, for example, mislead consumers. If they say we conform to high information management, cybersecurity, whatever standards, and they don't, well, then the ACCC can come in and say you misled consumers, but they have no general privacy data protection mandate, right? So they have some role in Australia, and there are some things happening. The Google case is an example of that with the settings, but they can't do everything. So either we could empower our regulator, come up with the massive penalties Europe is. That's one mechanism that requires, government money and really putting those resources in. But another mechanism is just to create, you could do it in the Privacy Act if you wanted, create a strict liability regime. So in the context of data breach reporting, you not only have to notify everyone who's been affected by that data breach, you've got to send them a check.
Wow, great answer. It just shows how complicated it all is, and having the lack of bodies to then police it all as well, right? There's another question about the slides. This talk will be recorded anyway, so you will be able to get this back. So that's fine, Grace. Now, Marina is asking about the second option. So she says, Love your crazy ideas, Lyria. Perhaps a second option could be augmented by allowing individuals to set their threshold of risk and only be presented with options that meet that setting.
Absolutely. So once we start the idea of searchable, we can do it not only for privacy policies in terms of what organisations say they're going to do. We could set up a search, for example, where you only find products that conform with a particular technical standard and have been certified in a sort of whitelist. You could do it on the basis of the disclosed risks. So if we did have that sort of requirement under consumer law that we have under, as I said, the sort of financial products laws, to disclose risks, you would be able to say, look, I'm prepared to accept this risk, but I'm not prepared to accept that risk. And again, making sure it's not just in words. No one wants to read the words. No one reads the words. I think someone put in a privacy policy at one point. I heard this, it might just be an anecdote, but anyway, it's a good one. They put in their privacy policy that the consumer agrees to hand over their firstborn child. And everyone, it didn't even change their accept clicks, right? So forget the words. Let's see how much of this we can make, if you like, machine consumable, make it into things that the search engines on the other end can limit searches by reference to. And then people will be able to search for risk, for particular privacy provisions, for anything. We should build them as much as possible. Let's give consumers the options. Then others will take that up, right? Because then the browsers will take that up and they'll make it a browser setting and so forth. So the whole sort of market, I think, will come out of the, but first we have to get to the legal bit. The bit the law has to do is make people do that, right? Make people not just write written English text privacy policies, but also code it in a way that the search engines can help people find what they're looking for.
Gosh, absolutely. As a psychologist, yeah, like, nobody reads that stuff, and you've just given a very good example of why. I'd love to add something to that as a question I had. There's a body of literature now talking about there's risk, but there's also harms, right? So there's a risk that something might happen, but people often don't understand what is the consequence, the harm of that happening, right? And I'm wondering, how does that perhaps work with option 2? And I'm sorry to be greedy to ask a question.
I think that's part of the consumer education piece. I don't think the law can help people understand harm. I just don't think the law, can really do that. That's more sermons rather than carrots and sticks. We have to be able to tell people and make people aware of the kinds of harms that can happen. And I know your work, Monica, in particular context, and the lecture you gave to Richard's students the other day, including in that, but the idea of, the risks of romance scams, right? Just as one example of in a cyber context. Most people, it literally wouldn't occur to them unless they've encountered someone writing about it, right? So let's get that information in the media, and the media do pick up on those stories. Let's get that, with op-eds about the sort of things to look for, like how do you tell, right? So there still has to be that, for lack of a better word, the sermon piece. And that's really hard to do, right? And me as a lawyer is not the person to design that program. I'd be going right back to you, Monica, as the psychologist. And maybe we need someone in education as well. What is the slip, slop, slap for cyber? So that's, again, coming back to that interdisciplinary point. The lawyers can't answer this on their own any more than the tech people can just solve a bunch of tech problems or we all really need to come together.
Absolutely agree. We've got another question from Marina, and I think that's addressing second option. She says, Lyria, will rules as code change this?
The machine consumable idea of turning privacy policies and risks, Marina, which was your suggestion and an excellent one, into that is actually to some extent inspired by the rules as code movement. For those who don't know what the rules as code movement is, because this is a broad audience, the first thing is join the Australian Society of Computers and Law because they have awesome panels on it. Essentially, it's the idea that at the moment, if you imagine the way we turn law into what computer systems do, is essentially government outsources, right? So the law will say government's entitled to collect debts from people in particular circumstances under welfare law, tax law, whatever it is, right? And then someone will go say, oh, build a system that will generate debt letters, and there you have robo-debt, right? And robo-debt is terrible because it doesn't actually track what the law was saying government was meant to do. It sent a lot more debt letters than the government was legally entitled to send, but it was just the system that was built, and government probably didn't build it themselves in-house, right? So that's a really bad way of doing it. A better way of doing it, and this is what Rules as Code is about, and it's also a really good one for lawyers and computer scientists thinking together, is what if we did that as an interdisciplinary code drafting exercise, right? So what if we got the software people, the computer code people, and the legislative drafters in a room together, working on two versions, if you like, of what the rules are going to be, the English version that goes in the statute and what the system is actually going to do when it's making welfare payments, collecting tax, whatever it might be. And let's put the rules that's meant to be applied directly into what the computer code does. Now, we could have a whole conversation about rules as code, but the point is that it means that systems are operating in accordance with the law quite literally. So in a sense, this is a slightly different idea, but it's certainly inspired by it, which is what we need is for systems to read things, not just the words. And privacy policies are just a really good example of the words aren't working. Gosh,
we could talk all day here, and I know we haven't got that much time, but I'll try and get a few more questions in. Rob Chalmers asks, accepting the need for higher level legal approaches rather than just narrower regulatory responses, how about strengthened obligations on data recipients for maintaining security rather than the generic, fairly slack governance standards in the CDR rules and the current more limited focus on data breaches?
Brilliant. Exactly the kind of ideation we want, right? Let's add that to the list. You know, and again, these have to be explored in more depth. And you know, I can't, you know, do the full analysis on my feet, but that is a fantastic suggestion, right? Let's think about that. Let's think about all of the ideas, right? But I think that's an excellent one. Thank you.
And we have a comment from Sanjay, so I might just go to the next question. That's Kali Kumar. Thank you for an excellent presentation. It is great to see other crazy idea people exist. I would love to see an example of your crazy idea one with respect to a past breach like that of Ashley Madison. Also, would such insurance restrict compensation to what is provided under the insurance? That is, would this encourage users to sue for onflowing damages or help restrict same?
Okay, so a number of questions in there. First of all, the law at its best, and it's not always perfect on this, should be prospective. In other words, as nice as it would be to fix all the problems of the past, law really should only impose liability where it tells people about that in advance. And for that matter, the regulatory effective law works best in that direction. If people don't know what they were breaching before it was against the rules, there wasn't very much they can go back in a time machine and fix. Right? We can't stop in other words, saying that we can't stop the breaches that have already happened. We can only try to reduce their number going forward. Now, I think the second part of that question is in terms of what will happen to sort of litigation. I think, you know, will it encourage or discourage people to bring suits? I think potentially it will. It's hard to know until you do it, but potentially it will discourage in the sense that some people will feel, at least at the lower end of the financial harm phase, right? People who are inconvenienced and worried about their identity and so forth, rather than having actually lost a lot of money. Those people, I think, will feel, look, you know, the company has acknowledged of the breach, and I'm going to mention that point in response to Ned Dobos's point in the chat, just up on the side of the screen, which is that, is there an incentive for data custodians to conceal data breaches? No, because they have to say that the law already makes them disclose those breaches. So yeah, they can breach the law, and yeah, people can go around murdering people too, but it breaches the law. So we have to build things on the model that most companies at least don't, you know, set out to break the law. That if there's a legal requirement to do so, most boards of directors will be like, we need to comply with that. There'll be some bad actors and there are some murderers, but let's put that to the side. sorry, going back to the other point, if you have the $100 payment and a notification of breach, and ideally, I think good companies now with good PR people, also an apology of some kind, a lot of consumers, I think, will feel, okay, you know, it happened, it's bad, but I've got something from it. I've got some kind of compensation for all the hassle and risk that I'm taking on now, and they won't take it any further. The people who I think still will, and we still need the law to protect, is where it actually, you can actually prove, if you like, the tort case, right? You can act, or the breach of contract, or whatever it might be. Let's you know, the context will depend on the context, but where you can actually prove that what happened to your data is causally connected to some very significant financial harm. And that's hard, right? That's where the law takes people most of the time now. And I imagine if people do go to lawyers, they just get told that's hard, right? The tort claim, or even the consumer law claim that the goods weren't fit for purpose and so forth, but also that you can get some kind of significant remedy for the very significant harm you suffered. Again, maybe a bit easier in some ways, harder in others, but you know, these are all hard. And most people, unless the financial stakes are huge, aren't going to go all the way through any of those remedy pathways. Some still will. So and I think we have to preserve that. So if someone really is, if there is a data breach, and that data breach really does lead to a significant financial harm, and you can do all the causal chains back, and there's no clause in the contract that disclaims liability or creates an indemnity or all the other things companies are trying to do, or if they do, it's not effective because of consumer law, then, you know, yes, let's not take away people's rights.
And Lyria, we've come to the end, unfortunately. There were a squillion other questions, but we've gone over time, I'm afraid, and it just proves what a fantastic talk that was. And people can look at the recording again if you want to. And I just want to say thank you so much for such an excellent talk, Lyria. Thank you.
Thank you, Monica. Thank you for having me, and thank you to IFCYBER for creating this wonderful interdisciplinary space.